So when you're listening to this, it is Friday, January 19th, but right now, this was so time sensitive, we needed to talk about it because we're on the floor at the Public Policy Show and some major news just broke.
Indeed.
All right, so we're here with Jim Ganther from Mosaic. Thank you so much for being the sponsor of our public policy coverage. And I think the timing couldn't be any better.
Couldn't be better.
Because some major news just broke about the FTC CARS Rule. Why don't you break it down for us, Jim, because you're the expert here.
When I read in automotive news that the Federal Trade Commission stayed enforcement of the newly minted CARS Rule, it blew my mind. I mean,
what is that? Break it down for people who may not understand what a stay is.
Which is most people.
Yes.
Yeah. This is a quick, just so everyone knows listening, Jim's face over the last 15 minutes, actually, it's been equivalent to finding out that like a kid
Shock,
finding out
surprise,
that they're going to Disney World,
excitement,
right? It's the same face, actually.
Sense of duty. It was all these things.
Yes.
Yes, it was a great hodgepodge of emotion, but it was emotional. Let's break it down. On the 12th of December, the Federal Trade Commission issued what they called the CARS Rule for combating auto retail scams. And I refer to this, please pardon my candor, as a steaming pile of judicial overreach. It's a slapdash, hastily assembled regulation that is going to make it more expensive to buy cars, more difficult to sell them. It's going to take longer in the F&I box, and it's going to make the product more expensive. Other than that,
Sounds
it's great.
consumer friendly.
Not in the least. So the National Automobile Dealers Association, NADA, and the Texas Automobile Dealers Association, TADA.
They're big.
Ta-da! They filed a petition in the Fifth Circuit Court of Appeals, which encompasses Texas, which is where TADA is. I believe, nobody told me this, but I'm assuming that NADA and TADA teamed up so that they had a basis to get the lawsuit heard in a Texas-based court rather than in the nation's capital, which is where NADA is resident.
Right.
So it's called, jurisdiction shopping, court shopping. They get in front of the right court, and NADA, TADA on about the 5th of January. Don't hold me on these dates. They filed a petition to stay enforcement of the CARS Rule and for expedited treatment. They wanted the court to hear the case quickly and throw out the CARS Rule as quickly as possible. But the first step is what we call a stay, meaning time out. Yep. We will not enforce the rule. We'll just maintain the status quo. Everybody put your guns down, and we'll calmly go to court and resolve this as gentlemen. All right. NADA filed its opposed motion for a stay. Under the rules, they have to ask their opponent, the Federal Trade Commission, are you going to oppose the stay? And the Federal Trade Commission said, of course we oppose it. So it was an opposed motion. I don't have the docket in front of me, but I believe that today was the day that the Federal Trade Commission had to file its brief in opposition to NADA, TADA's motion, and they didn't. Instead, just from what I read on automotive news, the Federal Trade Commission said, in the interests of justice, if they were interested in justice,
they took the high road.
Let's give them that.
That's their story, and they're sticking to it. We will stay enforcement so that we have an opportunity to go to court and do this in a more measured fashion. But let me tell you why I don't believe their cover story, and it is this. In order to get a court to issue a stay, one of the elements you have to prove is that you have a substantial likelihood to prevail on the merits. It's likely that you're going to win when we go to trial. If the Federal Trade Commission had submitted its brief and the Fifth Circuit had said, we're going to issue the stay, that would be a devastating defeat for the Federal Trade Commission, because a Circuit Court of Appeals would have said, you're going to lose.
So basically what happened was that there was a stay going to be issued, and the FTC said, you know what, we're not going to enforce. No stay necessary, basically.
Correct. They're
and
saying
that way they can't. They're not admitting
They're
a
not
loss
admitting
they're
defeat.
not admitting a loss. They're
or a potential loss.
This is how you try
A
to
likely loss.
This is what we call polishing a turd, and it is not always successful. I don't think anyone is really going to take the FTC seriously, that all of a sudden, in the interests of accommodating the automotive
Goodwill.
industry,
Right. Yeah.
that I
See,
think is
I think
patently
that's,
absurd.
That's a major nuance that I think the majority of people will not ever hear or understand.
Yeah.
In the sense that this is, if the FTC did not do this, this is actually like them admitting that it's likely not enough basis to have this, like stand up against like a legal review.
Correct.
Is that?
That's a true statement, but let's not do a victory lap just yet.
Right.
Because
I think that's important.
the rule is still the law. The rule is still the rule. The only thing that has changed is the date of enforcement.
Right.
You may recall 2 years ago, we got the revised safeguards rule. Just before, like a month before it became enforceable, the Federal Trade Commission stayed enforcement, but only of about half of its conditions. But they stayed enforcement for another 6 months. That's where we are right here.
Right.
The revised safeguards rule is in effect and is being enforced as we speak. This law hasn't gone away.
It will get enforced at some point.
At some point in some form.
Right.
So what I think is going to happen is this. I believe that the Federal Trade Commission believes that there is merit to NADA TAD's arguments. What were their arguments? Argument one was that you guys didn't even follow your own internal procedures in
To get
passing this rule.
going. Yeah.
It's a little subtle. The only thing they didn't do was issue an advance notice of proposed rulemaking, which would then be followed up after some interval with a notice of proposed rulemaking and then a final rule. They missed that first step, but they're not legally required. The law that required them to do advance notice was repealed. You're inhaling.
There's so much here. There's just so much. It's all nuance.
But
And
let me finish this
Yeah.
thought. But even though the law requiring the Federal Trade Commission to take that additional step, even though that was repealed, the internal rule, the internal procedure at the FTC is still on the books. And the Administrative Procedures Act is pretty clear that if you're going to issue a rule, you have to follow your own procedures. And it's pretty obvious the Federal Trade Commission did not.
yeah.
And
So-
go ahead. You can
Well,
pick me apart on that one.
No, it's not picking you apart. What
No.
I want to make sure happens is that this is kind of like a little bit of a whiplash, right? If I'm a dealer and I hear this and I can make somewhat sense of it, I may have been on a trajectory to start to put a bunch of things in place. What would you suggest to dealers who, like, even though this is the case, what are the next steps? What should their next 60 to 90 days look like in regards to this rule, pending rule, etc.?
Don't put down your guns and go home. I mean, this hasn't gone away by a long shot. We've won a battle, but the war is still ongoing. I just described what was the first prong of NADA TA's DA motion. The second prong was not only did you not follow your own internal procedures, but you had no factual basis for the rule that you made. You had no empirical evidence. You didn't meaningfully get the input from industry. You didn't listen to all of the people that had really a dog in the fight, like NADA. They made the point when we were still in the comment period. You have no empirical data. We want to engage a company to get empirical data. It's impossible to do in a 60-day window.
Yeah.
Right. Yeah.
Well, I believe that data study is still ongoing. I believe the Federal Trade Commission can take a step back and say, maybe you're right. Maybe
Let's
we
look at the
should do
data.
that.
Let's look at the data. Let's
Yeah.
talk to the customer. Let's talk to the end user. Let's figure out all the scenarios.
Let's do it right.
I think, that's as I've been looking at this and as I've been learning and understanding some things more than others, the intent of this rule, I think, is based in what should be a great consumer experience, what should be a better consumer experience. The problem that we face right now is that it actually will create dissonance in the majority of consumer experiences. And I think if dealers are going to do well by this rule, both at the FTC level, also at the level of lobbying, but also for the consumer, and show the consumer, no, we are actually for you, is to come with proposals and real data and real consumer study that says, hey, if we did it this way, it would be great for the consumer, great for the experience, great for the dealer, and great for the federal. And if we can do that, like as a dealer body, as an industry partner body, that right there will shift the narrative for the consumer.
It sure will.
If dealers right now, next 60, 90 days, what would I do? First of all, is I would take advantage of every opportunity I had to learn about what the rule actually did. What is the threat that we are still facing? And then I would take pains to make sure that doesn't happen at my store. One of the big things in the rule is the concept of offering price. If the rule is enforced, you're not allowed to advertise MSRP unless it is coincidentally your offering price, which is your total cash price, including everything that happens after the sticker on the window. So if you have a dock fees are dead. If you want to charge one, it has to be in the offering price.
This is going to be such a high topic of conversation in 2 weeks at NADA.
It's already the law, by the way. That is not made illegal.
Right.
Most of the things in the CARS rule have been illegal for 50 years.
Huge misconception, right? The things that are in the rule are already illegal.
Yes.
So why are they able to be done?
Oh, the reason why, this is my take on why the CARS rule happened in the first place. For decades, the Federal Trade Commission has been issuing fines for violations of what they would say Section 5 of the FTC Act, meaning unfair and deceptive acts and practices are illegal, and we have the right, under different sections of the FTC Act, to assess fines. Everybody lived with that. Everybody lived with the FTC enforcing fines right out of the box for decades, because the fines typically weren't that large. They weren't worth going to an appellate court or the Supreme Court until AMG Capital Management. AMG Capital Management was a payday loans outfit, and the stuff they were alleged to have done, I'm not familiar with the case other than the allegations. The allegations were dirty deeds. It looked like they did bad things, but the FTC did something that you could consider overreach. They fined them $1.27 billion.
Whoa.
And when you get fined $1.27 billion, you cannot afford not to go to the Supreme Court.
Right.
So that case went to the Supreme Court. All the facts were bad actor, we got to fine them. And the Supreme Court, in a 9-0 decision, they can't decide what day of the week it is 9-0. In a 9-0 decision, every single justice said, the FTC has no legal basis for doing this.
Wow.
And the FTC argued, yeah, but we've been doing it for a really long time. Tough. And so the Federal Trade Commission had to create a legal structure that gave them the right to assess fines right out of the box. That meant they had to create a trade regulation rule, which they can enforce with monetary fines. This is that trade regulation rule. So, dealers, start obeying the laws that are already out there. The biggest offense I see all the time is not advertising true cash price.
Yep.
You can fix that overnight. Another problem you can fix overnight, get rid of the fine print.
Yep.
CARS rule makes it illegal. Get rid of the fine print.
Fine print is dead. We said
fine
it earlier,
print is
you're gonna
dead.
Make a t-shirt that
Dealer
says that.
fees are dead. Addendum stickers, they can be done in a legally compliant fashion.
Yep.
But if they're adding substantial cost, that should be in the advertised price. If you fix these things, the FTC will not have a leg to stand on when they actually survey, they do real work and see who is really doing
we
bad
need
things.
wholesale real change that impacts the consumer experience right now, so that as the FTC and as consumers look at dealers, they go, nope, they're doing a great job.
That would be in the dealer community's
Best interest.
and I wish them well, and
You know,
hope
it's
they do
something
it.
like we should probably love some people more than we love profit.
Oh man!
Wow, coming in hot on a Friday. We got big news on a Thursday.
I know
it was nuts. We just the fact that we had you here on a day like today with that type of news
timing
gave us just sublime
kiss.
timing. Yes.
Glad to have been here.
Jim Ganther and Mosaic, thank you so much for making us our policy day coverage possible. Thanks for joining us, and look forward to having some more fun together in a few weeks.
All right,
at NADA.
See you in Vegas.